Hey guys, a lot of people are asking me about comparative negligence, comparative liability, and the new law. So I want to explain that to you, okay? So under the old law, if someone was 99% at fault for an accident, okay? Let's say they're crossing the street and it's not at a intersection where they're allowed to cross. They're jaywalking. They're cutting across the street in an area there's no crosswalk, okay? Under the old law, if that person is if a jury says, hey man, you're 99% responsible for this, but the driver was 1%, because if they maintained a proper lookout, they would have seen you running across that street and they wouldn't have clipped you. So in that scenario, a jury could come back. Let's say they came back with let's say the person had a massive brain injury and was injured for the rest of their life. And they said, you know what, we're going to award $1 million to this person, and we think that they're 99% at fault. The jury would apportion 1% of the liability of the $1 million, 1% to the at-fault driver, okay? Under the new law, if a jury finds that someone is 51% liable, that's the magic number, 51% liable to, quote, cause his or her own harm, then they recover nothing. So that first example where the guy was 99% responsible, but the driver for 1% failed to maintain a proper lookout, the jury will award nothing to the injured person in this case. Doesn't affect too many cases, to be honest with you, that my office handles. We handle mostly injury cases where someone slipped and fell, okay, and there's no warning sign. Maybe they were stopped at a red light and got rear-ended. Okay, those aren't going to be affected by this new law. What will be affected? Okay, I got here cases where a motorcyclist wasn't wearing their own helmet. Maybe a jury says, you know what, there's no law that requires you in Florida to wear a helmet, but we think that if you wore the helmet, you wouldn't have been so injured, so we're going to award you 0, because if they're found 51% at fault for to cause their own harm, they're going to get 0. Let's say a pedestrian crossing a street outside of a crosswalk, they may be held, depends on the jury, 51% liable, which means they get 0. Okay? Let's say a person wasn't wearing a seatbelt after an accident and they got really banged up. Maybe they're going to get 51% to cause his or her own harm. 2 cars driving in the same direction, they rub, they sideswipe each other. Okay, or they're merging. One car's going here, one car's merging. We don't know for sure which car bumped which, right? Those cases are going to be duds now. The people may be injured, but since it's a he said, she said, they're going to be able to recover nothing under this new law. They'll still have PIP benefits, but they will recover nothing. It'll be very unlikely that they would recover any money. Doesn't really affect too many cases. I understand that it could affect certain cases, but it's not going to affect too many cases, that are concerned. Obviously, the cases where there's the biggest one that I could think about in a car accident setting is going to be those cars. They're both making a left-hand turn. They're both in the left-hand turn lanes, and they're both turning left, and they bump sides. You don't know which car is responsible. Under the old law, both cars could recover some money, but under this current law, the new law, they're going to recover most likely 0, because it's a he said, she said, and if the jury comes back with 51%, the lawyer and the injured person make 0 money. So thanks for watching.